if the Constitution were used, which it actually was. The judge did release this. It did get to the judge. There was a degree of independence in the judiciary. The reason the judge kept it going for 2 weeks after the first revelation was that another point was that Nixon had offered him during the trial, during this period, to be director of the FBI, replacing Hoover, who had died, and Gray. And that was his childhood ambition, to replace Hoover someday as head of the FBI. So the Constitution, the idea of an independent judiciary and all these things are not self-enforcing exactly. A judge who wants to be appointed to an appellate level, to a higher level, as my judge would have been his second choice, has to get that from the president. If you want to be head of the FBI, you get that from the president. And that's a pretty strong lever that they have on this thing. And again, going back to my trial, for instance, people say the system worked, which is certainly true. Here I am. Here I am. If I'd been found guilty of all charges, I'd be getting out with good behavior in 2008. But let me tell you 2 other facts that cut both ways about my trial. It turns out, to my amazement as a layman, and even to my lawyers, that I hadn't committed any crime by any previous standard. Now that's true because of our First Amendment, it turns out. I got a very expensive education in this subject, something that probably most lawyers here have not had occasion. How many people here are lawyers? I see. Not so many. Yeah, okay. I've talked to good for all. I can talk freely then here. But I have talked to audiences of lawyers, and I'll tell you why that's recently, in the last couple of years, there's kind of an interest in this case for a number of reasons. We don't have, thanks to the First Amendment, a marvelous anarchist statement, or you prefer libertarian statement: Congress shall pass no law abridging freedom of speech. It's a restriction on Congress and, by inference, the executive. If Congress can't pass a law, the executive cannot do this either. And eventually, the Supreme Court ruled that even applies to the states as well. So you cannot abridge freedom of speech and of the press. Well, that has been modified a little bit on laws of obscenity and various things, libel. But, and there are, in fact, restrictions on putting out certain types of classified information, specifically communications intelligence, intercepts, the kind of thing the NSA does to foreigners and now to us. Yeah. And but revealing that is illegal. Come back to that in a minute. Second, the identities of intelligence agents, that's a relatively recent act after AG that arose in the Plame case, in the Libby, the revelation of Valerie Plame's name as a covert agent. And third, the nuclear weapons data, restricted data, design and deployment, various things about nuclear weapons. I don't object to any of those restrictions. They all are restrictions on free speech, you could say. They're criminal measures. But the idea of controlling all those is something that I don't even, nowadays, I've never objected to. What we don't have is what Britain has, and nearly every other country in the world. But the mother country has an Official Secrets Act, and has for a long time, which criminalizes any revelation of classified information or information that the government chooses to protect for whatever reasons of its own. Put in a safe, maybe it's stamped in various ways. Any revelation of that for any reason, intent is no element, is criminal. In fact, 2 people just got convicted, I believe, in England of violations of the Official Secrets Act for putting out some information that the public had a right to know, I would have said. But that's Britain. we got away from that, and amazingly, this is the country without an Official Secrets Act. Now, I didn't know that. I assumed there was. I'd been told that the Espionage Act amounted to an Official Secrets Act a dozen times when I signed agreements on secrecy, which is many times, every time I got a new clearance. When I was in the Marines, when I got promoted, so I was signing secrecy agreements, which I broke in the end. But I signed them in good faith, for sure, with no expectation that I would have a problem with those. Those are contracts, and the classification system turns out to be still an executive administrative order, an administrative system, for which, breaking of which, you're breaking your agreement, you can be fired, you can lose your clearance, lose access to particular kinds of information, or all kinds. That means lose promotions, maybe be fired, as I said, I think. But you can't be imprisoned. Actually, you can't even be fined. But your career can be ended, which is very sufficient disincentive for almost all occasions. What we don't have is what I was put on trial for. This is rather amazing, and I expect that hardly anybody here knows it, the lawyers or non-lawyers. Let me put it in the form of 4 facts, which you don't have to believe because I say it, but you can easily look it up. I put it to you that the following are facts. The U.S. does not have an Official Secrets Act. The Espionage Act was not meant to be an Official Secrets Act. In fact, in the legislation, when it was passed in 1917, many of the legislators said, now, we do not want an Official Secrets Act like Britain. It's too restrictive of freedom of speech. It's the way to run an empire like Britain. But we don't want to restrict freedom of speech that much. And of the press, the public has a right to know. So they're very specific. They referred to the British Official Secrets Act as what they did not want. The language of the Espionage Act does have language in it, nevertheless, that could be read to forbid what I did. In effect, an Official Secrets Act. But as I say, the legislative history would indicate that was some kind of an accident or something, but it wasn't meant. Second, if it were meant by Congress, it would still be very questionable or arguable in view of the Constitution. The act would be, in those days, 1971 now, and earlier, would have been regarded as unconstitutional. So first point, we don't have such an act. Second, as a result of that lack of a law, no one had ever been prosecuted before for a leak of classified information. So that's the second proposition. Mine was the first, with Tony Russo, the first prosecution for the leak of classified information. It was as unprecedented as the Supreme Court case just before it, the injunction, which again was ruled to be against the First Amendment. Third fact, nowadays, Congress actually did pass an Official Secrets Act for the first time in October of 2000. And fourth, by the way, with Janet Reno, mentioning Janet Reno's approval. So it's expected to be signed by the president. But after a protest by the newspapers, fourth, Clinton vetoed it. Now, so we don't have such an act. How many people here knew any of those facts that I just mentioned? Let me see. I don't. Oh, come on. Don't be shy. You did. Which one, by the way? Or all of them?
Didn't you say that in your book?
Oh, in the book. No, if you've read the book, that doesn't. Thank you. Who has not read my book? Who knew any of that? Well, supposing I'm right, and that's a safe assumption I'm telling you. Supposing I'm right, isn't that interesting that nobody knows any of that? And I can tell you that if you were all lawyers, at most one or two of you would have raised your hands at this point. And if you were all journalists, one or two might have raised your hands. Now, if you don't know you have a right, it's like not having it, and you don't notice when it's gone. You don't know, and hardly anybody knew, that they had passed this act finally, or that Clinton vetoed it.